Hello, everybody.
Good afternoon.
This is Linda Joy Kattwinkel. She's an intellectual property attorney that I've collaborated with a lot over the last few years. And she's been on the team that has developed the AIGA standard contract, the resource that AIGA has made available for a number of years. She and I just did an update to it, and that was sort of the topic of a session that we did yesterday. I'm Shel Perkins. I'm a graphic designer whose career has moved over toward the business side of professional practice. I'm usually in charge of operations for busy studios. I make sure that we have the right sort of systems in place. I deal with lots of different things, financial stuff, insurance, attorneys, to kind of protect the team from having to deal with those issues. I sort of run interference on those things. And today we want to talk about trademarks. So all of us, we're in the business of creating intellectual property and negotiating with our clients over ownership and usage. And it turns out that a lot of designers actually don't know enough about intellectual property rights. And today we wanted to focus in on trademark and talk a little bit about what makes a strong trademark and what makes a weak trademark. So we'll be describing a continuum.
So the idea is not to tell you anything you don't already know about branding, but maybe to let you in on how the law looks at what branding is and how that might not quite be what you think. So we're trying to get past some of the counterintuitive issues that happen in the legal sphere.
So we need to start off by explaining what trademarks really are. What is the purpose of trademark law?
And the law looks at trademarks as something that tells consumers the source of goods or services.
So the goal is to prevent confusion in the marketplace by identifying the source of a product or a service.
When you have trademark rights, that means that you have the legal ability to stop other people from confusing consumers by using your trademark or using something that's so similar to your trademark that people will get the brands confused. That's the basic basis of how the law looks at it.
And in your career, there will be issues that come up related to trademark infringement. And it's kind of challenging because trademarks can be infringed unknowingly. Even though you've worked independently, you haven't knowingly created a new mark that resembles an existing one, there might still be infringement. So we'll be talking about that, but it's something that you need to be cautious about. So design firms are involved in creating new identities for companies or products or services. So chances are most of the people in this room will be creating trademarks. And there are so many different things that can function as trademarks. So all of the options are kind of sorted into two piles. A lot of people talk about traditional trademarks, and that category includes these things: words, letters, numbers, phrases, designs, shapes, or combinations. And we have some examples for you of each one of those. So here's a traditional trademark in the form of a word. This is the name of the company. Here's another one that's in the form of a word, and this is actually a family name. It's a surname. Those of you who work in identity design know that there are also hierarchies. You might be working with a major corporate client that owns dozens of brands, especially in consumer packaged goods. So here's a little diagram that shows how those families work. And each and every one of these is protected as a trademark. A trademark can be a letter. So I'm sure you recognize which company this letter refers to. It can also be a number. One of the best known is 501, which has been used by Levis since about 1898. That's when they started to refer to one of their basic models as the 501. There are other companies that have trademarked numbers as well, like Boeing. They use numbers to identify their airplanes, like the 747. This is a traditional trademark in the form of a phrase. So on a lot of your client accounts, you'll be developing slogans. Those slogans can be registered and protected as trademarks. This is from the California Milk Processor Board. Another example would be Just Do It. This is another form of traditional logo, a traditional trademark. It's a logo, an image. So this one is fairly abstracted, but you could also have an illustration as your image. In this case, the illustration of a character. Here's another character. And should we mention?
I guess we should mention, full disclosure, I am Hello Kitty's trademark counsel.
So watch it. We have some Hello Kitty examples today because they're so much fun. This is another form of traditional trademark. It's a shape. So this is an image of a product that's been marketed since the 1950s. And the product line has a name, Car Freshener. It has kind of an unusual spelling, so that's protected as a registered trademark. But also the distinctive appearance of the product itself, that's protected, and it's referred to as the little tree, capital T, capital L, capital T. This is a traditional trademark that is a combination of a word and a symbol. Here's another one that we see every day. This combines a word and an image, although they're evolving toward a new format where they've dropped the words. So the other category that I mentioned is non-traditional. So there are a number of non-traditional marks that are interesting to talk about. Colors, smells, usually they're referred to as olfactory marks. Sounds, motion, some of you may be involved in creating animations that would be used as trademarks in the marketplace. And then also holograms. So just as an example, here's a trademark color. I'm sure you recognize this. It's a color that Tiffany has been using since 1845. And it's now registered as a trademarked color for exclusive use on jewelry packaging. So you could use this color on other products. And
yeah, you're not going to get into trouble if you use this color for auto parts, for example. But if you're, what's that?
It seems white to me.
It's like an aqua blue.
Yeah, the color, I'm sorry, the color on this projector is really off, isn't it? I don't know if we have a way of adjusting that.
It should be an aqua blue.
Yeah, it should be that robin's egg blue.
That's pretty bad.
So Tiffany is
Thanks
the
for
only
telling
company
us.
that can use that for jewelry packaging. Another example would be UPS Brown. If you had a delivery company, a freight company, and you wanted brown to be essential to your identity, UPS would probably sue you. Here's another non-traditional mark. So it's a sound ID that goes way back to the radio days of the 1920s. It became mechanized in about 1932, and then in 1950, it was granted protection as an audio trademark. It was the very first one. This is another non-traditional trademark for motion. This one is for the entertainment company Marvel. It was created in 2002 by the great Kyle Cooper, around the time that he was leaving Imaginary Forces to found Prologue. At Marvel, its nickname is the flip book or the zoom out. This is another non-traditional trademark. It's a hologram. So this one happens to be for Major League Baseball, but a lot of 3D logos are used for authentication purposes. A lot of them are used in the pharmaceutical industry. And I can't show you anything about an olfactory mark. There aren't a lot of them in the United States, and some of the olfactory marks that have been registered were later canceled. They're no longer being used. But the first one was for sewing thread and embroidery yarn that was plumeria scented. So they had made a non-utilitarian decision to use a scent to identify their product in the marketplace. So another example from a couple years after that, There was a company that manufactured industrial metal. It was oil that was used in industrial metal cutting, and they decided that they were going to give it a bubblegum scent. So if you're working in a machine shop and the oil smells like bubblegum, you would know which brand it was. Sorry? It was registered in 2002 by a company named Midwest Biologicals, although it may later have been canceled.
Chanel No. 5 or something?
Well, no, that would be a functional feature of the product itself. So, so for something to be a trademark, it can't be an important part of what the product is. It has to be kind of arbitrary. So
yeah, it's
you don't
a
need
non-utilitarian.
Yeah, so oil doesn't need to have a scent, but if it does, that becomes a possible brand as a way to distinguish it from other products.
So when you're talking about trademarks, especially when you're talking about the names of companies, products, or services, attorneys will often talk about something called the continuum of distinctiveness. And this is an important legal issue. So some trade names are very distinctive, some are not distinctive. And when you're working with your clients, you want to be creating names that are distinctive. So fanciful names are the most distinctive, followed by arbitrary and suggestive. Courts usually will rule that they are inherently distinctive in some way. A big step below that is descriptive. And we're going to be showing you examples of each one of these things. If it is a descriptive mark, it has to achieve secondary meaning in the marketplace, which we'll talk about. And at the very bottom are marks that are referred to as generic, and they really can't be protected. If you filed a lawsuit against someone for infringement, you would not be on a solid legal footing. So here are some examples of each category.
So a fanciful mark is basically a made-up term. It's not a word that we know in the English language. It's something that somebody created just to be a brand. In the way that the law looks at this, that's the strongest, most protectable, best kind of trademark you can have in the legal world. There's some tension because in the marketing world, it's also the hardest brand for people to understand immediately what it's about. You have to do a lot of education. But in the long run, the market also understands in the same way that the law understands that these become the strongest brands. Think of Xerox, and we're showing you Kodak. Names that are completely made up tend to be very strongly identifiable as brands for one particular company.
Right. Sometimes they're referred to as coined. So they're made-up terms that have no prior meaning. This one was made up in 1889 by George Eastman and his mother. They were using an anagram set to come up with a distinctive name. Another example would be Diageo, the large beverage company that's based in the UK, or Rolex for watches. Those were all made-up words. Exxon is another example of that. It's a fanciful trademark. Exxon was created in the 1970s. The next step down is referred to as an arbitrary mark. So here you have an existing word or phrase that's unrelated to the product or the service. It's considered to be inherently distinctive, but it's not quite as strong as a coined term. So Yahoo chose this name in 1994. It's actually been around since at least Gulliver's Travels, which was published in 1726. But Yahoo later on made up a story about how it was an acronym for something or other. But it's just a word that existed in the language that they decided to use in an arbitrary and unexpected way.
So arbitrary basically means there's no real connection between this word and the product or the service that it's being used to brand.
This is another example. So there's a candy bar that's named O. Henry. It was first sold in 1920, and it's an arbitrary use of words that were already in the language. Other examples might be Amazon or Target or Lotus, becoming the name of a software company. The next step down is a suggestive trademark. And this is something that requires some thought or analysis to determine the nature of the product or the service, but it's suggested in some way. It evokes some connotation or some feeling. It evokes features of the product or the service in a way that requires the use of the consumer's imagination.
So this tends to be kind of the sweet spot where most clients like to live, because they want the brand to have some sort of immediate connection and positive connotation to their product. So in this case, there's a speed suggestion by use of a Mustang in connection with cars, that has a more immediate suggestion, impression to consumers than a totally arbitrary use would have. But the way the law looks at this, the law thinks this is a weaker mark. It's still inherently distinctive. It's still protectable as a trademark, but it's not as strong as those arbitrary or fanciful brands.
This is another example. It suggests the business that they're in. It doesn't literally describe it. It evokes features of the product or the service. This visual presentation was created in about 1987, and it's still used on some of the company's products because, you know, Microsoft it's kind of decentralized, and a lot of the managers of individual business lines have some control over their own visual identity. Just ask Paula Scher.
So let me just break in there also. What we're showing you is a sense of what the law thinks is strong or weak when a brand is started, when it is first initiated and first introduced. Microsoft was a weaker brand than Apple. Why? Because Apple is an arbitrary use. It's a commonly understood word, but it has nothing to do with computers until Apple made it have something to do with computers. Microsoft, little bit weaker, little bit more obvious what the connection is. Both of those brands now are very famous, so they have become strong over time. And that's a different layer of what happens, the way that the law would look at them. So the law looks now at Apple and Microsoft as probably equally strong because they're both very famous brands now. So what we're showing you is kind of at the inception of a brand, where do they land on the law's view of what's strong and what's weak.
Another example of a suggestive trademark would be Coppertone. It's a suntan lotion, so it kind of, if you use your imagination, you can pick up the cue. A big step down is a descriptive trademark, and it immediately describes the product or the service. And it's weaker from a legal standpoint because it's not inherently distinctive. You're just describing something using ordinary language.
So what that means is if you're coming up with a brand for your client and it hits this descriptive category, it's not even going to be eligible to get a registration with the US government right off the bat. If it's a descriptive term, it's going to have to develop a consumer recognition over time before the government's even going to recognize it as a valid trademark. So this now, we're getting into the category of things to avoid as an initial branding idea.
Right, so you're using ordinary language to describe in a very plain and ordinary way features, qualities, ingredients, or the uses of the products or the services. And those words are already in the language. So the legal system says that over time, you're going to have to educate the public that there is a secondary meaning. The primary meaning is not what's protected. It would be a secondary meaning. And it takes a lot of advertising, a lot of PR to develop that secondary meaning over a period of years.
And this is something that frequently your clients may not understand because they will see marks like this already out there, like Computerland and like some of the others we'll be showing you, that they understand are already brands and that people view as brands. So they're not necessarily going to understand why can't they also have such a descriptive phrase as their brand. And the issue is that they can try and they can develop it over time, but it's not going to be recognized immediately as a brand.
Right. So if you go to a company, if you go to a store called Computer Land, what do you think they sell? Another example would be Park and Fly. What kind of company do you think they are? What is it that they're selling? So they must achieve distinction through sales and advertising, usually over a period of years. Here's a product, Shake and Bake. Well, how do you think you use that? What is it for?
So there's a tension because most clients will want these kinds of marks because they're so imminently obvious. And it also feels like they're able to create a monopoly over the space of this kind of mark. The problem is that it does take time, and in the beginning, they have no monopoly whatsoever in this kind of mark.
Descriptive trademarks can also include family names or geographic indications. There are a lot of businesses that have a place name, a city name, a state name. So this can also include geographic terms like Bank of America, which is geographically descriptive. And this one is interesting, Kettle potato chips. This was actually in the news lately.
Yeah, this is one of my firm's clients. They lost a battle to hold on to this as their trademark. The courts decided that this is actually a generic term that describes a certain way that potato chips are cooked, and therefore they don't own the word kettle. The only thing they've got now is this particular visual representation of that word.
So here we've dropped down to generics. The weakest kind of mark is a generic. It can't be protected.
And what the law is concerned about is they don't want any particular company monopolizing the way that consumers will normally refer to a particular product. So they do not want anyone to own this term kettle because they believe that the courts decided that anyone who uses the kettle cooking method to make potato chips should be able to call their potato chips kettle potato chips. And that's the point, is that the law is very concerned about not giving monopolies over the essential ways that we describe goods or services to each other in the marketplace.
So if the mark is generic right from the start, it won't qualify for registration. But there's another way for marks to become generics, and that is to start off as a protected trademark, and then over time slowly become generic. And that's usually referred to as genericide.
So this is kind of the gotcha side of coming up with your fanciful mark. That might be a term that you create. In this case, it was cellophane. It was a brand new product. Nobody had ever seen it before. Cellophane was a made-up, coined term to describe this product. But because it was the first word that anybody had to describe this product, the brand got confused with the name of the product, and eventually it became generic. This has also happened to aspirin. It's on the verge and keeps threatening to happen to Xerox. And you will see advertisements by these brand owners telling you not to use their term, not to use their brand in a generic way because they're afraid of genericide.
Right, which we'll talk about a little bit more. So cellophane was trademarked in 1912 by DuPont, and it was ruled generic by a court in 1936. This is another example. The word zipper for a sliding fastener was coined in 1925 by B.F. Goodrich. So it started off as a very strong mark. Now, they made a big mistake by not registering it until 1943. And by then, a lot of people had already started to use it in a generic way. So now, there are hundreds, if not thousands, of companies that make and market zippers. You can see on this ad, zippers are made only by Goodrich. Well, that's not true anymore. So we'll talk about ways to prevent genericide in a moment, but there are a lot of great examples. Escalator, thermos. If you do a search for genericide, you'll find lots of great examples. So if you are working in a creative company and you're developing new identities for clients, while you're actually working on that new ID, you'll be doing preliminary searches on the internet. You'll do a Google search just to see if there's something out there that's similar. When you are getting close to completing the project, you will be assigning copyright to your client because the client needs to own it. They're going to go on to register it as a trademark because they are the source of that product or service in the marketplace. So you won't be registering trademarks or policing trademarks. It's something that your client will do. But you've signed over copyright, then the client goes on to use it. But before they put it into use, there needs to be a comprehensive search to make sure that you haven't, just by chance, infringed on an already existing mark. So the registration process is preceded by a comprehensive search. And you're going to put it into your contract if you're creating some new identity. It's going to be written into your contract that a comprehensive search needs to be conducted, and you want to place that responsibility onto your client.
So remember that trademarks can be infringed unknowingly. You can come up with something that just happens to be very similar to somebody else's mark. So you're not in a very good position to guarantee that what you're doing is not an infringement. It's not enough to know that you didn't explicitly or intentionally copy anything. And that's why we urge you to make sure that you've got a very clear obligation on the part of your client to do this searching. Now, if the client doesn't know anything about it and doesn't know how to do this kind of trademark searching, you can help them find a reputable trademark searching firm. Usually you need intellectual property counsel to interpret the results of a trademark search. You can help do that, but make sure that if you are involved in that, that is something that's very clearly laid out and that the costs of that are taken care of in your proposal, because it can be a costly enterprise to do a trademark search.
Right, so typically it's done by an outside service. There are private search services like Thomson & Thompson, they're the largest. So the client has to specify whether they want a word search and or a design search, whether they want it to be just for the US, whether it needs to be international, and they need to use a trademark attorney in order to order the search, to place the request for the search, because there are a lot of variables. There are some default settings that will show results, but you'll want an attorney to format it.
So basically, when you ask us, I'm one of those attorneys, we think about what is this brand supposed to represent, what kind of market is it going into, what kinds of goods and services are on the edges or are related to the core services of your client, because trademark rights will extend into any types of goods or services that the consumers might think are related. So we're careful in structuring the contours of the search to match what we think the legal liability could be.
Right, and you're going to be getting information that has come from federal registrations, state registrations, things that have appeared in advertising, things that are online, maybe other sources like product labeling databases. And typically the default format in the search results is to show you the things that are closest first, either in name or appearance. So here's a sample page from some search results.
You all recognize my client at the top. We just ran this as just a sample to show you what the search kind of looks like when you ask for it. This would be a design search that's looking for other two-dimensional images of cats.
Right, so when you get results like this, you might not be sure what exactly you're looking for. What matters, what does not matter, how much risk is involved, how much change might be required to your new proposed mark in order to avoid problems. So you also need an attorney to analyze the results. You're going to get dozens and dozens of results. There might be a couple of things that are clearly conflicting, things that are obviously very similar, and maybe they're in the same product or service category. There might be some things that are obviously not conflicting, they're just very distant. But the challenge is that most results are actually going to be in the gray area in between. So this is what an attorney is going to analyze. They're going to be looking at each one and making an assessment of the likelihood of confusion.
So when I look at that evaluation, I look at there are up to 12 different things that courts analyze to figure this out. Their basic standard is there a likelihood of confusion between these brands in the marketplace? How do you figure that out? Well, it's about how close are the marks, how close are the goods and services, what's the field look like? Are there lots of other cat images in the field of children's goods, for example, for Hello Kitty, or are there very few? If there's few, then the range of differences between the marks that will still be infringing can be pretty broad. If there's a lot of them, then the law says, well, you know, consumers have already seen a lot of cats in this field. They understand how to see the nuances and the differences between these different designs, and so the scope of infringement's going to shrink, and it's going to be easier to be closer to the cat design and still be okay. That's called the crowded field. There's also looking into, has there already been any confusion? That's an important factor. If there has been, the courts are going to be pretty well persuaded that that means there will continue to be. When you're designing a new brand, you don't really have the opportunity yet to find out about actual confusion, so then the courts look at that as kind of a neutral factor. What kinds of channels of trade are you going to be using? Are you in a stock brokerage kind of service where there's a lot of middlemen, as opposed to a different kind of service that is talking directly to consumers? If there's that kind of gap, that will help avoid confusion. So there's a lot of these different factors that we look at.
And the risk of trademark infringement has to do with the likelihood of confusion. That's the legal test for it. So the attorney who's analyzing these results is going to make a decision for each item in the results about the likelihood of confusion.
I'm going to take a question.
Okay.
Go ahead.
Is there a reason why the example of the Hello Kitty doesn't have a face?
Well, Hello Kitty does have a lot of different permutations of the way that she's represented in the marketplace, and one of the more recent configurations has been that outline image. My client started using that, I want to say, at least 5 years ago, and we did have to go through a new series of registrations to register that outline on its own, and I just thought it would be an interesting, a better example of the kind of broadness that a design might take on.
So if a decision is made...
Specific now than it would have been with the face.
Right, but because the Hello Kitty image is so ubiquitous and so famous now, we believe that, and we were justified in this with our filings to the Trademark Office, that the outline itself is already its own brand.
Yeah, so I know there are great questions coming up, but you're going to have to hold off just a little bit. We have a lot of information that we want to cover, and then we'll come back and open it up for discussion. Otherwise, we're going to run out of time. So if a decision is made that there is no likelihood of confusion, then it's okay to move ahead with the registration process. And there are several different kinds of registration. Your client might need guidance on this. The main thing is that they want to go through federal registration with the U.S. Patent and Trademark Office. So there's a lot of information on their site at uspto.gov. And again, an attorney would have to be involved because the application process is pretty detailed. There are filing fees. And if this new mark is inherently distinctive, it's going to qualify for being listed on the principal register. Being on the principal register means that a lot of people refer to that as being fully protected. It brings a lot of different benefits. If the mark is not inherently distinctive, then it has to go on to the supplemental register, which I always think of as purgatory. So they're going to be kind of parked there until they develop over time secondary meaning. And if you get to the point where you can demonstrate secondary meaning in the marketplace, then you can reapply and go on to the principal register. So the principal register is where you want to be because the supplemental register has fewer benefits. A lot of people say that the mark is only partly protected. In a lot of instances, there will be two registrations, one for the word and one for the design. So it sounds like that was maybe the situation with Kettle. Ultimately, it's the design that's being protected and not the word.
So now all they have is the design, yeah. There's a lot of benefit to registering design marks separately. And obviously in the design world, we believe that the image is very strong on its own and doesn't always need to have the wording with it. Especially if what you're designing for your client includes a system where the logo is a standalone mark and is going to be used separate from the client or brand words. You will want to encourage them to get that separately registered. But again, the registration process, unless you're working in-house, in which case all of this is completely your job, it frequently is going to be the client's job to work with this registration end of the process. But you need to be aware of what all of this entails because you're designing towards these ends.
Right. So just to recap what we've been discussing so far, if the mark is inherently distinctive, it qualifies to go on to the principal register. If it's merely descriptive, it has to achieve secondary meaning. So it's going to sit here on the supplemental register for as long as it takes. And some things never leave the supplemental register. They always stay there. And if it's generic, well, it didn't qualify for registration in the first place. So over time, if a descriptive mark has developed secondary meaning, then you do a new registration and you move it up to the principal register. Trademark registration can also happen at the state level, but this is kind of for historic reasons when most trade used to be local. So it's largely obsolete because it doesn't apply to interstate businesses, interstate trade.
Yeah, I mean, basically today, if you're on the web, you're going across state lines, and so you really are looking for federal registration.
There are also international registrations. So if your client is an international business, they're going to need guidance on this. Prior registration in the United States can be helpful, but it's not really necessary. And international registrations are complicated. They're probably going to go through a separate process and receive different protections in each country where they have a presence. Although in some areas like the European Union, if you do an EU registration, it's valid for 28 countries at once.
And again, this is something that your clients will be interested in, and sometimes the preliminary screening searches, the clearance searches, will have an international scope if this is a brand that's going to be international. That will be part of the evaluation, and the registration process will also be taking into account how to do it most effectively and most efficiently internationally.
Once you have federal registration in place, then your client is going to have to renew that periodically. And a new mark needs to be reviewed and renewed in 5 years. And that might also be an opportunity to prove acquired distinctiveness if it was on the supplemental register. And after that, registrations are valid in 10-year chunks. So it has to be renewed every 10 years as long as it's being used in business. So in the United States, there is this requirement that the trademark has to be used out there in the marketplace continuously. If it hasn't been used over a 3-year period, it's considered to be abandoned. And under US trademark law, theoretically, anybody else could scoop it up, register it for themselves, and start to use it. And that's actually what's going on right now. There's a lawsuit involving Macy's. Maybe you guys have been reading about this in the news.
Yeah, so this is a very enterprising guy who decided to scoop up all of these abandoned famous trademarks and reignite businesses under them. The courts are struggling with what to do about this because on the one hand, it's very clear that Macy's, the original owner, did abandon these marks. On the other hand, it's also very clear that the new guy is trying to trade on the reputation that these marks represented. Remembering that trademarks are all about the reputation and the goodwill that comes with the brand recognition, it's a quandary for the courts to figure out, is this brand recognition something that Macy's still owns, even though they're not themselves using the brand anymore? And we still have to see what will happen with this lawsuit. My personal opinion as a trademark lawyer is that if there is brand recognition still there, it still should be protected, and other people shouldn't be able to come and use it. That's a very different situation than, say, somebody else with the last name Filene's wants to start their own store, and they're not using the same logo type and not trying to trade on the old reputation, but simply trying to start their own brand under a name that would have been infringing if Filene's was still around. That's a different question, and that's the kind of situation that the law is trying to protect. They're trying to say, you don't own a brand name forever. If you stopped using it, someone else can start up. But where the line is between this famous mark and its old reputation, we're still waiting to find out.
Right. So it was probably a mistake for Macy's to let these go dormant for so long, because under trademark law, technically they are abandoned. Some clients don't register their trademark at all. They go ahead and use them out there in the marketplace, but they haven't gone through an official registration process. Over time, through usage, they might accumulate some common law rights, but those would be limited to where it's actually being used. It would be limited to just a certain amount of local protection. Common law rights are not as strong, and they're harder to police and defend.
It's also a concept that's peculiar to what we call the common law countries, which are countries that started out as British colonies. Most of the world doesn't recognize a trademark as valid unless it has been registered. So that's another thing for you, if you're in-house, or your clients, if you're independent contractors, to be concerned about, is to make sure they're not relying on common law rights outside of the U.S.
So when you see a little TM or an SM symbol, that means that the client is planning to enforce whatever common law rights may be available to them. And usually that's just a temporary placeholder while the actual federal registration is going through. That may take a year or so to be finalized. So eventually the TM and the SM would come off and the circle R would go on.
Let me just add, I know there's a lot of tension in the design community about these little pesky TMs, SMs, and circle R, little gnats that look terrible and mess up your designs. Our country has a kind of schizoid view of this. On the one hand, it's not critical to have these little marks next to your trademarks for you to have the protection. On the other hand, if they're not there, certain types of remedies are banned, or you're barred, or your client will be barred from getting them. So our recommendation as trademark attorneys to our clients, because we hear this all the time and I'm totally sympathetic to it, is to find one place in any particular application where you can put that R in a circle and have it be fairly meaningful and fairly observed, and then not worry about using it every single time. That there is kind of a fair medium balance between those two concerns.
Right, so we've talked about the process of creating a mark, hopefully a strong one. You're handing it over to the client. They're going to go through the registration process because they own it. They are the source in the marketplace. Over time, though, identities evolve, and this is going to include you. So the design firm will be involved in various steps of the evolution. As a descriptive mark gains distinctiveness, it can maybe move up from the supplemental register to the principal register. But there are also updates or redesigns or additions to the identity system that can make it stronger. So here you're coming back into the picture. And you do have to be careful when you're updating or freshening an identity. If you change it in a really radical way, you're going to lose whatever equity it had acquired in the marketplace, especially if it was a descriptive mark. So we have a couple of examples for you. This is a timeline that I found on the internet. that shows the evolution of the Kentucky Fried Chicken identity. And you can see that it starts off as a descriptive mark. It's fried chicken, which is descriptive, and it's from Kentucky, which is descriptive. And over time, they abbreviated it to KFC, which actually starts to take it out of that descriptive category. It starts to move it up a notch. Another example might be Washington Mutual, the bank that's no longer with us, but that was probably one of the reasons why they became WAMU instead of Washington Mutual. So here's a different example that's maybe not as good, maybe not as strong, from a legal standpoint.
Right, so when you see a rebranding that completely changes the look of the logo and the whole commercial impression, now you're starting over. Now all of the equity and the goodwill that was developed in the original brand has been abandoned, and the new mark is a new mark. It's starting over. Now, I mean, the good news is the new mark is also a distinctive mark. It doesn't have a strong generic or descriptive or ornamental kind of presence. It has a branding presence, so it starts its own new goodwill, but it is a complete break with the past.
Now, sometimes clients might want that if they've been involved in some sort of scandal. If the old identity has acquired very negative connotations in public opinion, then they might want a clean break. But in general, you want to keep your existing trademark rights continuous and intact. Another part of trademark evolution that's really interesting is the development of trade dress. So over time, most well-known products or services develop what's called trade dress, and those are multiple components, multiple aspects to the visual identity, and it has to do with the overall appearance of that product in the marketplace. So this is part of trademark law that protects that total image of the product or the package or the promotional campaign. It can include size, shape, color combinations, texture, graphics, but they have to be non-functional. They have to be distinctive but non-functional, and it's intended to protect a brand from unfair competition by imitators and copycats. So one of the best examples of this is Coca-Cola.
So I want to make sure we understand that it's a bottle, right? That's functional, but there's nothing functional to dictate what kind of shape this bottle is. So Coca-Cola comes up with their distinctive, unique shape for a bottle. They get to own that shape.
Right, so the formula for Coca-Cola itself was developed in 1886 along with the name, and very soon after that there was the visual representation of the name in Spencerian script that was eventually registered as a trademark in 1893, and it's been redrawn a number of times over the years. I think the most recent was done by Landor in the 1980s. But the distinctive contour bottle that Linda Joy was mentioning, that was designed in 1915 and introduced to the market in 1916. Since then, they have added other components to their trade dress. So starting in about 1919, they worked with designer Raymond Loewy. He was commissioned to do branding work, and he decided that they should emphasize the colors of red and white. Much later, they added that kind of wave form in the late 60s, probably about 1969. They call it the dynamic ribbon or the white swirl. And around that time, they were working with the design firm Lippincott. They have alternate names for their products. So Coca-Cola is also called Coke. In the 1960s, they registered Coke as a trademark. And they've developed various slogans. So do you remember phrases are a traditional form of trademark? So they've had things like "It's the real thing" or "Things go better with Coke" from the 1960s. And they mix and match aspects of their trade dress out there in the marketplace. In their promotions, in their campaigns, in their point of purchase materials, all these elements get mixed and matched. So that's an example of trade dress. So you might be involved in the evolution of a mark, you might be involved in the development of trade dress. Over the long haul, though, the client is responsible for policing it. So we have a little bit of advice about policing, and there are two aspects to that. One is quality control. just to protect the reputation and to show that it's not being abandoned. So that's where Macy's screwed up. But also there should be efforts to prevent potential genericide. So guidelines are needed to avoid genericide, and sometimes this has to do with the grammar. So if you're a copywriter, if you're an editor, you have to know that from a grammatical point of view, generics are usually nouns, and trademarks are generally adjectives. So the generic term almost always follows the trademark. For example, Band-Aid brand adhesive bandages, or Kleenex brand tissue. So a protected mark should not be used in the plural as a possessive or as a verb. So a lot of people say, oh, that image was photoshopped. Well, photoshopped would be, that's a misuse of that mark. Or Googled. You should Google it. Well, Google's not a verb. The mark shouldn't actually be used in that way.
Mm-hmm. Or I need to Xerox this. These are all ways that brands start to look like they're generic terms.
Right, so brands that are afraid of that, sometimes they'll run ads in the creative community. Maybe you guys have seen ads like this in communication arts or in print magazine. This is one from 2007 from Xerox. If you use Xerox the way you use zipper, our trademark could be left wide open. Here's another example. This is an ad that ran in advertising and design magazines in 2011. And they point out that the outline of the little tree is protected as trade dress. If you want to use it, you have to get their permission. And there's no guarantee that they'll give you that permission. They think of it as a valuable part of their intellectual property. So most corporations will hire a watch service to look for unauthorized usage or conflicting marks. They'll at least sign up for something like Google Alerts. So some companies have in-house legal counsel that stays on top of this. I would assume that Disney and Mattel and Lucas probably have in-house counsel. Others would use an outside trademark watch service. And you get to negotiate that service. How detailed do you want the reporting to be? How broad do you want the reporting to be? They're probably going to be looking at things like new state and federal filings of trademarks. And then if something shows up in one of those reports, your client has to decide how to respond. They have to make a decision about whether it seems to be infringement or not, or whether it's something called dilution, which we'll look at in a minute. So if they're going to respond, there are a lot of different ways that they could respond. There's kind of this escalating response.
These are a list of factors of how we look at whether a new mark is an infringement of an old mark. And this is the same evaluation, whether we're looking at something you've just designed that we want to make sure is safe, or somebody else has designed that looks like something your client now owns.
So we're going to share just a couple of examples of infringement and dilution. This is a really famous example of infringement that we talk about actually a lot. It involves the logo for NBC. So the peacock logo that they used to use was designed in 1956 by John Graham, and it had 11 feathers. And by 1974, they decided that it was just sort of embarrassing. It was so old and quaint. So they hired a New York design firm, Lippincott, to create a new identity. And Lippincott put a team on it. They spent about a year. They charged close to $1 million, and they delivered this. And NBC started to implement this identity. They started to apply it to the 1,000 things, and in the middle of all of that, they got a phone call from the general manager of a little public broadcasting company in Nebraska, and he said, "You stole our logo." And we're in the same industry. So you create television programming, and we create television programming. When people see this at the beginning of a program, they're going to be confused about the source of that product. So we're going to sue you for trademark infringement. And NBC realized immediately, oh yeah, we're really sorry. They negotiated an out-of-court settlement. Reportedly, they gave them about $1 million of cash and broadcast equipment. And you know that immediately they would have gone over to Lippincott and asked what happened. And I have no idea what was in the Lippincott contract, but hopefully it pointed out that a comprehensive search was required and that the client had responsibility for that. Ultimately, NBC was so burned by the whole thing that they went back to the peacock. So in 1979, 3 years later, they went back to the 11-feathered peacock. And then in 1986, they went to Chermayeff and Geismar to create an updated version that has 6 feathers, and that's basically still what they're using today. Here's a different example. This one is not trademark infringement.
So we put this in to emphasize that trademarks are not blanket monopolies. They are limited to the goods and services that they're used for. And very similar marks and identical names can coexist if they're not in related fields. And this is an example of that. It's hard to see because it's not even green on the screen anymore. The green one is the Canadian mark for the film board industry up there. The other one is for an organization that fights child abuse. Very, very different services. So even though these marks are very close, there's not an infringement problem here.
This next example has to do with trade dress. If I can get this to advance.
Uh-oh.
I think we might be freezing up here.
There you go.
So this is a package for oatmeal cookies that's been on the market for quite a while. It's from a company called Archway, and they have a competitor named Voortman, and Voortman Cookies introduced this package. So they got sued. Archway sued them for trade dress infringement because it had to do with the overall appearance of this product in the marketplace. The color palette, the use of imagery, the layout of the packaging. And in 2009, a North Carolina district court issued an injunction prohibiting Voortman from, quote, advertising, distributing, selling, or offering to sell cookies in this package. So the other thing that we mentioned just a moment ago was dilution. So I don't know if you guys are familiar with the concept of trademark dilution, but there are a lot of lawsuits in this area. There might be trademark dilution even if there's no likelihood of confusion.
So dilution is a special concept that the law has developed for very famous brands. It's a way to protect brands in the neighborhood of Xerox or Disney or Apple from having their mark become diluted by having other similar marks exist in the marketplace, even if they're not on the same goods or services. So the first threshold is it's not available to anybody. It's just available to famous marks. And there's 2 types of dilution. One is called blurring, and that just means that, for example, Apple is no longer just the trademark for computers, but it's also out there for auto parts. That's a blurring. That's a dilution by having more than one of these marks out there. The second one's called tarnishment, and that means that the mark is out there used with something that's offensive, that's actually a derogatory association.
Right, so my favorite example of this is something from California. So I don't know if you guys can see the imagery. The color is totally off. But this is a classic example of trademark dilution, and it involves a drug dealer. So in 2006, there was a drug dealer in California who was selling his products in these candy packages. And he was initially arrested just for selling the drugs. So he was convicted in a criminal trial of being a drug dealer and sent to prison. And once he was already sitting in prison, then the candy companies became aware of it. So you might see that one of those labels says Rasta Reese's. This is what his package looked like. And these are the real packages that come from the candy company.
I'm sorry about the color. Just imagine the color is the real color from the real candy package, and it's duplicated in his drug packaging.
Yeah, maybe the lamp in the projector is getting ready to go out. So this famous chocolate company sued him, not for being a drug dealer per se, but they sued him for trademark infringement because he had copied their logo. They sued him for trade dress infringement because the packaging is so similar. And they sued him for dilution by tarnishment because they're selling candy to kids. And they've put 100 years into building up that reputation, and he's selling drugs to kids. So obviously that associates their famous brand with an unsavory product. This is a completely different example, and this one involves our favorite brand, Hello Kitty.
So Hello Kitty has had a rash of tarnishment in the field of guns, especially lately when the whole issue of guns and whether they should be regulated has been in the news and very highly discussed online. Some people have decided to put Hello Kitty on guns, and we've had quite a bit of activity in this front, and this is obviously a tarnishment. Even if most consumers would have the good sense to know that Hello Kitty's not about guns and would not license a gun, this is a tarnishment because it's creating an association between Hello Kitty and guns in our minds just by seeing it, even if we know it's not real. So that has some legal consequences.
Right. Now the person or company who did this, their defense might be, oh, it's a parody. But it's not really a parody, and we'll talk about that in a minute. We'll share some information about what constitutes a parody. So your client is trying very hard to police their trademark out in the world, and they have to figure out how to respond to unauthorized use. And this is that kind of escalation that I mentioned. They might send an informational letter saying, you know, please don't do it, or if you use it in this particular way. They might negotiate a license. They might say, oh, there's some synergy between our businesses and we're willing to license our identity to you. So technology companies license their trademarks to retailers to use in advertising campaigns. Or if they don't like the way that it's being used, they'll send a cease and desist, saying that you have to stop it immediately or we'll sue you. If they sue you, that's obviously a lawsuit. At the same time, they might be doing a counterfiling with the U.S. Patent and Trademark Office. If they feel that your new mark is confusingly similar to theirs, they'll contact the people in Washington and say, well, this other mark shouldn't have been approved in the first place. They can try to get the registration canceled. And this kind of challenging or counterfiling with the USPTO is something that happened recently with App Store.
And the result was App Store is generic.
Right, it's a lawsuit that went on since, I think it started in 2008.
Yeah.
Yeah.
So there is a downside to challenging. Sometimes it doesn't go your way.
Right. Now, getting back to parody, parody is one form of fair use. So U.S. copyright law has a whole section that talks about fair use. Trademark fair use is something that has come out of the courts. My understanding is that it's more of the court's interpretation of how trademark law applies.
That's fair. Yeah.
Yeah, and courts generally will recognize that there are three types of fair use. You can use a mark in an unauthorized way in these three categories and be safe from legal problems. And the first way is nominative. So if you're talking about a company or a product or a service, you can use its name. You're actually referring to that company, so that's just nominative.
And that comes up a lot if you're doing any comparative advertising, for example. If you're saying my brand is better than this brand because of X, Y, Z, you're allowed to name that brand. That's what nominative is about.
Right, and our use today is nominative. We're talking about these famous brands and we're showing you their identities because that's the subject matter. The second type of fair use under trademark law is called descriptive, and this has to do with descriptive marks. If you're using that descriptive word or term in its primary meaning, its regular common language meaning, then that's okay. You can't refer to it based on its secondary meaning because that's what's protected. So one example of that might be All Bran. There's a breakfast cereal that's called All Bran, and that's a registered trademark. But there are a lot of products that could just descriptively be described as containing All Bran. And then the third area of fair use would be parody.
So parody is my favorite thing. It happens a lot. It is a little bit risky in the use of brands for parody, but it does happen, and the courts are pretty good at recognizing what is a genuine parody. In the trademark field, The most important thing, of course, is whether consumers are confused. So a parody has to be a pretty good parody. It has to be clear that you're making fun of a brand and you're not confusing people.
Right, so here's an example of that. Here's a very famous brand. You see a logo here that's been applied to a very famous product. A luxury handbag from a luxury goods provider, and here's a parody.
Now, Louis Vuitton is very litigious. They really like to police their brand. They sued over this, but the court said, consumers know the difference. They know you're not making dog toys. They know this is a parody. So from a business perspective, this was a risky call because it did involve litigation. It did provoke litigation. And the client who wanted to manufacture and market these toys had to take that on as part of the risk of what they were doing, even though most of us trademark lawyers would have given the advice that we think you're going to win on a parody defense. That doesn't mean you're not going to have to go through litigation and spend the fees. So that's something that if you're in-house, you need to think about whether you want to commit those kinds of resources to a fight for this, or if you have a client doing this, you want to, have that conversation about what are the risks involved. The risk is not just whether or not you win or lose on the law, but what kind of costs is it going to involve. The other thing on the positive side is this got a lot of press. I think these dog toys probably sold a lot more because of the litigation. So if your client's in that kind of mind frame, that could work to your advantage as well.
It was a marketing expense?
Yeah, exactly.
Here's another parody. So the famous French graphic designer Cassandra developed this logo for Yves Saint Laurent in 1963, and it represents one of the best known brands in high fashion. Here's a parody that's called the Proletariat shirt, and it's poking fun at the high prices that some people are willing to pay for status goods. This is another recent parody that probably some of you have seen. We're all familiar with Whole Foods Market. Here's a recent parody. It was I think it was created by someone named Franklin Taggart, and he has it posted on his website, but he's not selling stuff. He's just poking fun at the famous brand, and it's not in a an obviously offensive way. It's not linked to any offensive product. Here's another well-known parody because this actually has been through the court system. So here's the famous brand, and here's the parody. This was created by a man named Charles Smith.
And he went through litigation. Now, this guy wasn't even working for anybody else. He's just making his own parodies, but he was selling T-shirts. He still, I believe, sells these T-shirts because he won in the courts. Here's the difference. A parody is a commentary on the brand. And in this case, it's pretty clear what the commentary is. Even though it's being sold as part of a product, as part of a T-shirt, and the T-shirt is something that Walmart also sells, the message of this parody is what the courts look at, and they're saying, we see this is a message, it's a critical message, it's a commentary, it's fair use.
And it's on a non-offensive product. That's very different from the Hello Kitty gun that we just saw. That showed a famous brand that was being placed on an offensive, reputation-hurting product. Now, here's a different example involving Hello Kitty. This one's called Mellow Kitty.
So the commentary here, in case anyone isn't that clear on Hello Kitty's official character, would not be consistent with this depiction. So it's kind of a mockery. It's a parody of her.
So it's not tarnishment to make a comment about a brand, but it is tarnishment to put it on an offensive product, and that's what this is.
So here's what's happening now. We've got a whole rash of Hello Kitty drug paraphernalia. This is tarnishment. It's not parody. It's an actual offensive product, and this is the difference that we need to understand as designers, where we're safe and where we're not so safe if we want to use somebody else's famous brand.
Right. So just to recap, a strong trademark is distinctive right from the start. your client has registered it, and then they defend it, they police it and defend it in the marketplace. And your role in the process, you kind of come in and out of the process. You're going to take the lead in creating the new mark. The client then registers it and polices it. You'll be brought back into the loop to help with its evolution, especially if over time you're developing trade dress. And if there is fair use out in the marketplace, nominative, descriptive, or parody, that's pretty much beyond your client's control. They can decide how they want to respond to it, but in certain circumstances, the courts will rule it to be fair use. So now, I'll just point you toward a couple of additional sources of information. Linda Joy has written a lot of articles for AIGA and also for the Graphic Artists Guild, and I think most of them are also posted. Yeah, they're all on the website of the law firm that she's part of in San Francisco. And a lot of the information that I use in my consulting and with my teaching is in a book that's available from new writers. It's called Talent is Not Enough. So now we can open it up to questions. So just for the recording, he's asking about abandoned trademarks. So Macy's made that mistake in abandoning all those regional names. How is that different from maybe Hostess going bankrupt? And someone acquiring the Twinkie name?
Asset and then reusing it for something different.
Well, the mark has to be unused for 3 years in the marketplace. And I think the Twinkie bankruptcy and then their new kind of funding, that all happened pretty quickly. That was just within a matter of months.
So the way that the law looks at it is possible to buy and sell trademarks and to acquire them through bankruptcy or acquisitions or things like that. And what happens in that situation is the law will consider that you will acquire the trademark rights and the goodwill that came with it if you continue in the same kind of business. So it's a little counterintuitive because it's not really our experience, because if a new company keeps making Twinkies but changes them, we as consumers don't experience that as the same product. But the way the law looks at it is it's a continuation of that brand, and it will keep those trademark rights alive. So the way that U.S. law works, they have something called a doctrine of foreign equivalence, and they look at whether the foreign word is itself, in its own language, arbitrary, suggestive, and so on, or if it's been on the marketplace long enough to acquire distinctiveness, it'll get trademark protection based on that analysis in its own native language. And so it will have the same kind of trademark rights as an English word. And the other thing about foreign words is they also look at whether an English equivalent is infringing, and the trademark office, more than the courts, believes that foreign translations are equivalent. So if you have a German word that means sugar, and you are trying to register, somebody else has registered that word, and you're trying to register the English word sugar, and say it's arbitrary, say it's for jeans, the sugar application will be blocked because it's the foreign equivalent of the German word.
So the question is about the use of the circle R or TM or SM. If you make it so tiny that it's not legible, is it still serving a legal purpose?
I haven't seen a court case on this, but I think it's a really good question, and my guess is the courts will say it needs to be legible or it's not going to work as an actual notice. Yeah. So
Yes.
in that case, what I would recommend for my clients is that they have, in addition to the typical copyright notice line we see at the bottom of web pages, that we have a trademark notice line that just repeats XYZ is a registered trademark of this company, and that will take care of your notice requirement even if you can't see the little symbol next to the logo. Okay, so the question is, and thank you for mentioning this because we didn't explicitly say this, but of course everything we've talked about today also applies to your own trademarks for your own design firms, your own names. So the question is, once having registered here in the US, you're starting to get letters soliciting registrations in other countries, and do you need to worry about that even if you're not doing business there? There's two reactions I have to that. One is there is, unfortunately, a very strong scamming practice out there where people are taking advantage of the fact that your registration data, even your application data, submitted to our U.S. Trademark Office is now available online, and people mine that data and send solicitation letters pretending to be different things. Frequently they are pretending to be registration services in other countries, or they are pretending to be registration services in this country, asking you if you want to renew or if it's time to do this or that filing, and looking like they're official services, and frequently they are not. So that's one caveat, that some of these letters you're receiving may not even be from official country registration offices. In fact, most country registration offices never solicit individuals for registration services. It's just not something they're into. They're already overworked with people voluntarily coming to them to register, so they're not out there looking for it. The second thing is, more to your point of, do you need foreign registrations if you're not out there? My general answer to that is not until you become famous or you're about to become famous. So for example, the large law firms, the large design firms in New York who have an international reputation probably should have registrations in Europe and other countries to prevent poachers from pretending to be them in those countries. But if you're a smaller business and your reputation and your presence is just here in this country, then I would not worry about it. I wouldn't pay attention to those letters.
So unfortunately, we're out of time. There is a feedback function on the Head, Heart, Hand application, so feel free to give feedback on the session through the application. And right now there's a break that I believe ends at 4:30. So thank you very much.